today's class, we would be discussing the unitary features. As we say unitary features, these features are not the federal features. This goes against the concept of federalism, because federalism is where the union government and the state government are independent, are separated, division of power is there, clear division of power. Even we have a clear division of power, which is mentioned in list system. That is, the list is there and we have a unitary list, we have state list and concurrent list, and union list has more important subjects, more number of subjects are there in union list, and also the residuary powers which is not mentioned in either of these three lists is within the jurisdiction of the parliament. So, to understand the Indian concept of federalism, we need to understand what are those features which forms the unitary features, that is, they are against the federal features. As we can say, we generally have two types of federation. One is holding together federation and one is coming together federation. We have a concept as holding together federation because we have a single entity. India is a single entity and we have divided our states for administrative convenience, and our states have not come together by an agreement. We voluntarily has divided the states for convenience of administration, for giving good governance. So, we cannot say that as United States have smaller states came together to form a bigger and stronger union, they have the concept of pure federalism as followed in United States of America, Switzerland and Australia. They are coming together federation. Ours is a holding together federation. What we follow is holding together of federation, like India, Spain, Belgium. These are the countries which follow the holding together federation. And Canada is such a country which we have a relativeness. We have got inspired from the Canadian concept of federalism. So, in this class, we would be discussing the various unitary features and we would also be criticizing the concept of federalism. So, first is the flexibility of the constitution. Here, when we say the flexibility of the constitution, it is the method, the method to amend the constitution or the way to amend the constitution. Is it flexible or rigid? As just to understand, the rigidity of the constitution is a federal feature. That is, the union government cannot unilaterally amend the constitution. We have a single constitution both for union government and state governments. Though we have a single constitution and the constitution is the source of power for both union government and state governments, here most of the provisions mentioned in the constitution can be easily amended by the parliament. That is, by simple majority or by special majority, most of the provisions can be amended. Here when we say special majority, we have two types. One is 2/3 of the members present and voting, and those 2/3 of the members present and voting should be more than half of the total member of the house. That is one special majority. And third is again the same thing, 2/3 of the members present and voting and should be more than total number of the houses, and that bill should also be ratified by more than half of the states. So, that is also one part of special majority. So, there are very few provisions which has this special kind of majority with the ratification of more than half of the states. Here the states have also been considered in passing the bill or in bringing any act. but most of the provisions like creating new states, changing the boundaries of the states or renaming the states can be done by a simple majority. Just you can pass the bill in the parliament and by just simple majority we can create a new state. So here the state's power has been reduced. States have not been considered in most of the provisions in making law. The constitution itself has given the union more power. That is the reason most of the features are unitary features and very few features are there which are federal features. So when we say the flexibility of the constitution, the amendment of the constitution or changing the provisions in the constitution is not rigid. Rigidity of the constitution is federal feature. Flexibility of the constitution is unitary feature. So we say the flexibility of the constitution, changing or amending the constitution is easy, and unilaterally a parliament can amend the constitution. Most of the provisions, I am not telling all the provisions, but most of the majority of the provisions mentioned in the constitution could be amended by the parliament in a unilateral way, that is by not considering the states or not taking the opinion of the states. So obviously this thing, amending of the constitution, which is mentioned in article 368, has been a matter of conflict in many things. States are not generally happy when parliament passes a bill or makes a law which is not in the interest of the majority of the states. See, what happens is when there is a ruling party at the center and not the same party in the state, so there would be a conflict of interest, and if any bill which is not in the interest of the state is passed by the parliament unilaterally without taking the opinion of the states, most of the states would feel that their autonomous state has been challenged. And there are many cases in Supreme Court also regarding this. But as we know, our constitution has given more powers to the union, and constitution is the ultimate source of authority. So generally we do not find any answer for this. Most of the critics have criticized, saying that the union government is more powerful in matters of emergency and again in various matters like the power of Rajya Sabha, where the Rajya Sabha can initiate the parliament to make laws mentioned in the state list, to make laws on the subjects which are mentioned in the state list. So definitely there is a overriding power given to the union. Here we are talking about the flexibility of the constitution, which is a unitary feature. So here in flexibility, many provisions could be amended easily. So as we know, in SR Bommai case, the Supreme Court has clearly mentioned, though we have given more powers to the union, but federalism is a basic structure and the union government cannot bring any such law which causes any harm to the concept of federalism, then that law would be declared as void. So we have many cases regarding this, but here as we know, federalism is a basic structure as given by the Supreme Court. We generally do not tamper with the concept of federalism. What we need to agree here is union government obviously holds more power when compared to state governments in the amending powers of the constitution. That is one thing. More power vests with the center. This is true because the Schedule 7th of the Constitution, which divides the power among the states and the union government, has mentioned more subjects in the union list, As we know, we have three lists: union list, state list, and concurrent list. So the important subjects which has a strategic significance has been mentioned in union list. Subjects like defense, subjects like communication, which also gives very important or strategic location, strategy of the India, like we have foreign relations. So all these subjects are mentioned in the union list. Matters of election, matter regarding citizenship. So all these subjects are mentioned in the union list. Important subjects which has an impact on sovereignty, secularism, integrity and unity of the nation are been mentioned in union list. Not only important subjects, but most of the subjects, that is in numbers also, around 100 subjects are mentioned in union list, and in state list we have around 66-67 subjects. So here union list is there where important subjects are being provided, and most of the subjects are also mentioned in union list. So here we say the power vests with central. As we know, most of the thing or most of the conflict happens where the finance is have a significant role. Generally we see most of the grants come from the union to the state government. So the matters related to finance have been a bone of contention between the union and the state government. Before Niti Aayog, it was Planning Commission which used to decide on the allocation also, and that is the reason now we do not have Planning Commission. We have replaced it with Niti Aayog, but again things have not changed. So generally we see more powers vest with the center. You take any power right from bringing law on concurrent list, or we have many subjects which are not mentioned in either of the three lists, that is union list, state list and concurrent list. So we also have many matters which are left as residuary powers, and on those subjects it is only parliament which could bring law. So states have nothing to do with those subjects which are not mentioned in above three list. So obviously it is union government which has become more powerful, and it is the constitution which has made union government more powerful with respect to state governments. One is that the constitution guarantees more power with respect to the union list. Obviously it is the parliament which can make law on the subjects mentioned in the union list. The subjects mentioned in the concurrent list can also, in concurrent list generally both state government and union government will make laws, but where there is a conflict on such law between union government and state governments, it is the union government's law would prevail. So here also union government, that is central government, has a overriding power with respect to the laws made by the state government. So we can sense that state government has a very limited powers to make law, that too on day-to-day administration, that too on not so important subjects, that is law and order, education, health. So these are the subjects which generally the state governments would make law. Here the parliament can make law which has a overriding power. We can also say that the residuary subjects which are not mentioned in either of these lists is under union government. The union government would make law on the residuary subjects also. యూనియన్ లిస్ట్లో చాలా ఇంపార్టెంట్ సబ్జెక్ట్స్ మెన్షన్ చేసిబడి ఉంది. ఇంపార్టెంట్ సబ్జెక్ట్స్తో పాటు ఎక్కువ సబ్జెక్ట్స్ కూడా యూనియన్ లిస్ట్లో ఉంది. ఏవైతే చాలా ప్రామినెంట్, చాలా సిగ్నిఫికెంట్ సబ్జెక్ట్స్ ఉంటాయో అవి యూనియన్ లిస్ట్లో మెన్షన్ చేయబడి ఉంది. రెసిడ్యూరీ అంటే ఏ సబ్జెక్ట్ అయితే ఈ మూడిట్లో మెన్షన్ చేయలేదో, యూనియన్ లిస్ట్లో, స్టేట్ లిస్ట్లో, కన్కరెంట్ లిస్ట్లో, ఈ మూడిట్లో మెన్షన్ చేయని సబ్జెక్ట్స్ వేరే చాలా ఉంటాయి. అలాంటి సబ్జెక్ట్స్ మీద ఒక చట్టం తీసుకొచ్చే బాధ్యత కూడా పార్లమెంట్ మీదనే ఉంది. పార్లమెంట్ మాత్రమే అలాంటి సబ్జెక్ట్స్ మీద చట్టాలు తీసుకురావచ్చు. కన్కరెంట్ లిస్ట్లో ఉన్న సబ్జెక్ట్స్కి యూనియన్ గవర్నమెంట్ మరియు స్టేట్ గవర్నమెంట్ రెండు చట్టాలు తీసుకురావచ్చు. కానీ ఎక్కడైతే కన్ఫ్లిక్ట్ వస్తుందో అక్కడ యూనియన్ గవర్నమెంట్ చట్టం మాత్రం ప్రివైల్ అవుతుంది. స్టేట్ గవర్నమెంట్ చట్టం అనేది అక్కడ వర్క్ చేయదు. సో యూనియన్ గవర్నమెంట్కి ఓవర్ రైడింగ్ పవర్ ఉంటుంది ఈ విషయంలో. అందుకే మనం చెప్తాము ఎక్కువ పవర్ అనేది యూనియన్ గవర్నమెంట్ దగ్గర ఉంటుంది. Unequal representation of states in Rajya Sabha. This is one of the unitary feature. So we have Lok Sabha and Rajya Sabha. As we said, bicameralism is a characteristic of federalism. Bicameralism అనేది ఒక ఫెడరలిజం యొక్క కాన్సెప్ట్. అంటే ఉభయ సభలు, రెండు సభలు ఉంటాయి మనకు పార్లమెంట్లో, రాజ్యసభ మరియు లోక్సభ. రాజ్యసభ అనేది స్టేట్స్ని రిప్రజెంట్ చేస్తుంది. లోక్సభ అనేది ఒక ఇండియా మొత్తాన్ని రిప్రజెంట్ చేస్తుంది. సో లోక్సభ ఎలక్షన్స్ అనేది డైరెక్ట్ ఎలక్షన్స్. మనము ప్రతి స్టేట్ నుంచి ఒక కాన్స్టిట్యుయెన్సీ ఉంటుంది. ఆ కాన్స్టిట్యుయెన్సీ నుంచి మనము ఎలక్ట్ చేసి రిప్రజెంటేటివ్స్ని లోక్సభకి పంపిస్తాము. రాజ్యసభ అనేది ఎల్డర్ హౌస్, అది స్టేట్స్ని రిప్రజెంట్ చేస్తుంది. సో హియర్ why we say unequal representation? As we know, every state should be considered equally. That is what the concept of federalism is. Irrespective of its size, its population, all the states should have an equal representation in Rajya Sabha. That we generally do not follow. In United States of America, we have Senate, which is elder house. ఇక్కడ రాజ్యసభ ఎలా ఉందో అమెరికాలో సెనేట్ అంటాము. మనకి అమెరికాలో 50 స్టేట్స్ ఉంటాయి. ఆ 50 స్టేట్స్ నుండి ప్రతి స్టేట్ నుంచి ఇద్దరిని తీసుకుంటారు. సో సెనేట్లో 100 మెంబర్స్ ఉంటారు. సో ఇర్రెస్పెక్టివ్ ఆఫ్ ద సైజ్ పాపులేషన్, స్టేట్ యొక్క జోగ్రఫీ అది సైజ్ కానివ్వండి, అక్కడ ఉన్న పాపులేషన్ కానివ్వండి, అది పట్టించుకోకుండా ప్రతి స్టేట్ నుంచి ఇద్దరిని ఖచ్చితంగా రిప్రజెంట్ చేస్తారు సెనేట్లో. సో వీ డు నాట్ ఫాలో దిస్ కైండ్ ఆఫ్ ఫెడరలిజం. ఇన్ ఇండియా we have Rajya Sabha seats depending upon the population of the state. స్టేట్ యొక్క పాపులేషన్ అనేది నిర్ధారిస్తుంది ఎంతమంది అక్కడ నుంచి రాజ్యసభలో ఉంటారో. అండ్ వీ జనరలీ నో దట్ రాజ్యసభ ఈజ్ నాట్ పవర్ఫుల్ యాజ్ లోక్సభ. లోక్సభకి ఇంపార్టెంట్ ఫంక్షన్స్, ఇంపార్టెంట్ పవర్స్ ఉంటాయి. లోక్సభతో కంపేర్ చేస్తే రాజ్యసభకి చాలా వరకు తక్కువ పవర్స్ ఉంటాయి. ఇంపార్టెంట్ బిల్స్ తీసుకురండి, అన్నిటికంటే ఇంపార్టెంట్ మనీ బిల్ అనేది రాజ్యసభలో ఇంట్రొడ్యూస్ చేయలేము, లోక్సభలో ఇంట్రొడ్యూస్ చేస్తాము. సో దేర్ ఆర్ మెనీ సచ్ థింగ్స్ వేర్ లోక్సభ has been more powerful. Obviously it has to be because the people there are elected directly. The representatives of Lok Sabha, MPs, are elected directly by the people. So when we compare their powers with Rajya Sabha, indeed the Lok Sabha has more power. But what is concerning here is when we say bicameralism is a characteristic feature of federalism, we do have bicameralism, but in that bicameralism, Rajya Sabha is weaker. We say Rajya Sabha has no power when compared to Lok Sabha. It has very lesser power. So the representation of the states in the upper house is based on the population. Unlike United States of America, in India, the members in the Rajya Sabha are dependent on the population of such states. Smaller the state, lesser the members in the Rajya Sabha. So we also have some states where only one member is represented in Rajya Sabha. That is simple, smaller states have lesser representation. UP is the largest state and most of the seats are occupied in the Rajya Sabha from the state of Uttar Pradesh. So this is one concept. So we can say that unequal representation is a unitary feature and which is not a federal feature. The executive is a part of the legislature. So who is the executive? Who is the executive here? We know ours is a parliamentary form of democracy, parliamentary form of government. We have not opted presidential form of government which is followed in United States of America. We have parliamentary form of government which is followed in England, Britain. So here the executive, as we know, we have three organs: legislative, executive and judiciary. These are independent to each other. Our constitution has mentioned it. We have three independent organs, though they are integrated but independent. So here the executive is a part of the legislature. We know we have a member of parliament, MPs, both from Lok Sabha and Rajya Sabha. Lok Sabha MPs are elected directly, and we have indirectly elected members in the Rajya Sabha, but those members only could become a part of the executive. That is what we have, representative form of democracy. The members of the parliament are the members who head the department or ministry. We have a ministry, we have a portfolio where under which minister is a member of Lok Sabha or Rajya Sabha, or if any such member who is not a member of either of the house can also become a minister, provided that within 6 months that member should be a part of either of the house. He or she may be elected to the Lok Sabha or nominated to the Rajya Sabha, but there is a time gap. Within 6 months of taking the charge as minister, that individual should be a part of the parliament. That is only provision what we have. Otherwise, no one can be minister after 6 months of the expiry date. So only 6 months is the grace period. Any individual who is not a minister or not a member of the parliament could only be an executive. Here when we say the executive is a part of the legislature, it means only the elected representative and a member of the parliament can be the executive. As we know, for any ministry, we have a political head and we have a administrative head. Administrative head would be a bureaucrat, maybe IAS, IPS. So a senior officer would be heading as the administrative head of that ministry or a department. And it is the minister who is a political head, and we call that political head as an executive. We have a cabinet form of government. Cabinet is nothing but we have a council of ministers. Council of ministers are the core members of parliament who will be heading such ministries or departments. Within the council of ministers, very strategic, important ministries are given to cabinet. So cabinet is a very powerful body within the council of ministers. They are the real executive. So here cabinet ministers and their portfolios, like we have defense ministry, home ministry, health ministry, we have law ministry, education ministry, agriculture ministry, all these external affairs ministry, finance ministry. So all these ministries which have a very strategic importance would be in the cabinet, and cabinet is a highest decision making body in the parliamentary form of government. So we say executives and legislatures are interlinked. So again here this is a unitary feature of the Indian government or Indian administration, where the federalism, the concept of federalism has been narrowed. So federalism is where the states and union have co-equal powers, but the central government, as we say in the earlier feature, central government is more powerful, and it is the union government which is a highest decision making body, and those ministers are the members of the parliament. So definitely there is an upper hand given to the union government. So this concept of having the executive part of the legislature is against the principle of division of powers between different government. So here definitely the state's power has been undermined. Going to next feature, Lok Sabha is more powerful than the Rajya Sabha. This we have understood because Lok Sabha is a directly elected body, and in numbers also Lok Sabha has at least double of the members in the Rajya Sabha, and Lok Sabha has many important functions to do. When there is a joint sitting also, obviously it is the Lok Sabha which prevails. So in unitary features, when we gave more powers to the Lok Sabha, it is against the federalism concept. As we say, bicameralism is a federal concept. We do have bicameralism in the name of Lok Sabha and the Rajya Sabha, but here Lok Sabha is more powerful than Rajya Sabha. Rajya Sabha is representing the state and Lok Sabha is representing the union. So here states or the units have been undermined. They have very less power when compared to Lok Sabha. So unequal powers will be against the concept of federalism. So Lok Sabha is powerful, and that is the why we call it as a unitary features. Emergency power. This is a very important aspect. As in our constitution, we said that India as a unity, India as an entity can become unitary government or federal government depending upon the circumstances. Circumstances in sense, when there is a breakdown of constitutional machinery or when there is a threat of war or external aggression, we generally transform or shift to unitary form of government, and emergency powers with the union government will make it possible or simple. Without changing the constitution, without amending the constitution, just using Article 352, Article 356 and Article 360, national emergency, President's rule, that is internal emergency and financial emergency. These are the articles through which the normal conditions of the India would change. Normally, we have parliament which bring laws on national important subjects mentioned in the union list, and we have autonomous state governments where the people in the state would elect the MLAs or members of the legislative assembly. So states also have equal significance, equal importance, and constitution itself given the power to the state governments. But in times of emergency, those directly elected body in assembly would dissolve. That is, the parliament can become the only authority in entire nation which could bring law on all entire union, that is entire India. So the emergency provision is in the hands of the union government. Through president, the government can bring emergency provisions. They can apply, that is, they can impose national emergency. The government can also impose through president the president's rule and financial emergency. We have not experienced a financial emergency till date, but this article, Article 356, has been most used article. Actually, it is most misused article because president's rule undermines the autonomy of the state, the independency of the state. It might be a political vendetta where the president, by the aid and advice of the cabinet, could impose president's rule. And we have seen in history many times. We have seen in Bihar, in erstwhile Andhra Pradesh, in Tamil Nadu, in many states, we generally see president rule which undermines or overrides the democracy at the state level. So when without amending or without changing the constitution, we have these articles where there is a smooth transformation from federalism to unitarism. So this undermines the provision of emergency, undermines the autonomy of the states. This is exception. Nowhere we generally find this kind of provisions mentioned in the constitution, where the constitution itself gives powers to the union government. So emergency power is a feature of unitary government. This is one thing. When we say the feature of federalism, it is independency of the judiciary. Federalism concept itself says that the powers of judiciary should be independent. There has to be a separate judiciary for the union government and separate for state governments, because it is the judiciary ultimately which interprets the constitution. In our case, we have independent but integrated judiciary. In United States of America, there is a separate judiciary for federal government and separate for provincial governments, that is regional governments or state governments. But in our case, we have integrated judiciary. We have a Supreme Court at the top level, then high courts, then district courts, then all other courts. So, Supreme Court supervises the entire judiciary system. Everything in the judiciary has to be supervised or administratively supervised, superintended by the Supreme Court. We call it as a apex court. So, right from appointment, transfer and all those day-to-day administration is supervised by the Supreme Court. So, where is the question? Where is the question of autonomy? So, we generally do not think there is a autonomy given to the states. Had we had a separate judiciary for the states, for example, we have high courts, but they also directly functions under the superintendence of Supreme Court. So, we say we do not have independent judiciary. Independent judiciary is a federal feature. We have integrated judiciary, and Supreme Court rests in the national capital Delhi, and the judges of the Supreme Court like Chief Justice of India, various judges of Supreme Court, judges of High Court are appointed by the President. So, President obviously is a national figure. He represents the nation. So, this becomes a unitary feature. Integrated judiciary becomes a unitary feature. Had it been independent judiciary, we would have considered it as a federal feature. But in India, though it is independent in sense, it derives its power from the constitution, and it has to be working independently from other two organs, that is legislature and executive. In that case, it is independent, but not horizontally. But we say here we have this concept of hierarchy in the judiciary. So, they are integrated at all the levels, and Supreme Court is the highest court. So, it is integrated, and this is a unitary feature. We do not have separate courts for the states.